Hi everyone, I'm immigration lawyer John Khosravi. Thank you for joining us today, August 25th, for our regular Q&A live, taking your general immigration questions, right? Some general education about the U.S. immigration process because it's confusing and there's a lot going on and a lot of changes. So I come live every Wednesday for over a year now. And I changed the time to 6 p.m. Usually it was 5 p.m. I need to get the notices out, but we're spending half an hour and sometimes longer taking your questions, and I also give free consultations as a raffle. So if you're watching the live version of this, like, subscribe, and put it out there that you like to have a consultation, and then I will every 10 minutes or so name somebody who won, and we'll send information on how to get the free 15-minute video consultation. So we'll talk about your case and you get some advice there. Other than that, then let's get it started. But before I start, I want to talk about something that's it's a confusing form that I want to mention. It's called Form I-824, and it's a form that has many different uses. But I was watching an old video I did. I thought I'd bring some. I talk about it to give you some guidance on it. So there are different situations where you need the USCIS to take an action, and the two of them, the most times that I've dealt with the need for this I-824 is this. You may have a situation where you start a green card case inside the United States. So you get married, you have a case pending, and then for some reason you have to leave the United States and you can't come back. We already have started your case in the United States, and for USCIS to send it to the foreign embassy for continuing and completing the process, they won't just do it willy-nilly. You have to submit this form and wait a while to get it. Unfortunately, the form usually takes a while to do and it costs money, but that's the process for that. Another scenario that pops up where you need the I-824 is if someone, was, like, let's say, applying for a green card. They got the green card in the United States, but their spouse or child, who could also get a green card because of that relationship, they're overseas and they're not coming to the U.S. anytime soon because they may have school or work that's keeping them outside the United States. So the primary beneficiary gets the green card, that applicant, and once they're done, they should have filed an I-824 to notify USCIS, now that my case is finished, please send it to the embassy so my immediate relative or close relative that's part of the case could also finish their case overseas or outside the United States. It's not always overseas, sometimes in Canada or Mexico. But that's the point of the form. Now, the problem is that it usually takes a while. You have to follow up on it, call USCIS. Although it's supposed to be something that's automatic, that you do beforehand for it to be automatic, it's not always the case. And we got some questions right now coming in about the COVID-19 vaccination and immigration. So I think that's a great question to start. Jordan 8350 is asking, is the COVID-19 vaccine now mandatory to get a green card? What a timely question to ask. So yesterday they had updated the CDC website, and USCIS updated pretty much today, saying that if you're filing for an immigrant visa, this is the green card, there's already a set of vaccines you have to get, Tdap, MMR, the flu shot if it's during the winter, and potentially a couple more. And if you had the vaccines already, you don't need to do them again, but you need to show paperwork that you've gotten them. And they made it mandatory that as of October 1st, all cases where a green card has to be decided to get a green card, those people will have to have had the COVID-19 vaccine. So, okay, a lot of people have it already, but I have a lot of clients, and enough, that are saying they're worried about this. They don't want to get the vaccine. I have to respect their wishes. What do? We have to try to get a waiver. And to be quite frank, that's not something I've handled before because all my clients have gotten them. But now, researching the situation, getting a waiver of the vaccine requirement is technically possible, but it's up to the discretion of USCIS and the officer reviewing the case. It's not an easy thing. For example, they talk about if there's some moral or religious grounds for it, and so you have to show that you maybe generally do not get all the vaccines. So if you're picking and choosing, that may not work. You have to make a good argument and see what they say. The other options when it comes to this stuff is maybe if the doctor could confirm that the person is going to get maybe sick if they get the vaccine. They have some sort of documentation to show that, and the doctor can write it up. Yeah, that might be a way to do it. Or you have some sort of health conditions that prevent you from getting it, or the doctor makes a decision that it's not appropriate in your case. So it's not, there are ways around it, but it's going to be hard, and it's not going to be easy. But if you worried about that, you'd want to get your case done before October 1st. But the thing is, we have no control over this of how soon they're going to decide a case. So the case that have that green card pending, I'm not sure if the case is going to get done before October 1st. So very likely that they'll have to, come in and do it themselves. Now, come do the vaccine. So thanks for the question. We'll see what happens, but it's a problem for a lot of people. It's a follow-up question. What if I take the COVID-19 vaccine not approved by the U.S. will have a problem? For example, AstraZeneca. The CDC has the website, and even USCIS has a breakdown of what they find acceptable and don't. Just check out that website, and they might update it, so check it out and do whatever they say there. We have a question from Srinivas, a regular. When the I-140, that's an employment-based green card petition, is approved, does it make any difference between EB3 straight and EB3 downgrade from I-485 processing standpoint? There are nuanced differences. I don't do these kind of cases where someone's doing EB3 downgrade, so I'm not a good resource for questions about that. But there are some technical stuff and some things that happen. For example, if you're doing premium processing, if you submit it straight or you do regular processing, then pay for an upgrade to premium processing. Colleagues have noted some differences in processing, but I'll talk with an employment-based immigration attorney about something like that. Our next question, Alassane Diop asks, what's the difference between the I-130 and K3 visa? And is the fee the same? Isn't the fee the same? Well, no. I mean, an I-130 is a marriage case. If you're looking at it between a K3 and I-130, I-130 is when you submit a form for a family member. But if you're looking in the marriage context, the I-130 is you're married and you're starting the case. Once that's submitted, you can submit a K3 through Form I-129F to request that USCIS expedite that so that the foreign spouse could come to the United States faster and finish up the green card paperwork here. Now, there is no fee for the K3 Form I-129F if submitted after the I-130. The goal is just to maybe expedite the I-130. There's only a handful of these a year, maybe let's say there's 10 a year if that's a lot of K3 being approved. K3 was necessary back in the day when marriage cases would take more than a year. Now, for the I-130 to be approved, but now it's not that big a deal, so it's not something that immigration attorneys file. But again, there's no filing fee for it, but it's an option. Some people want to try to push the issue. I don't like generally doing the K3 because what happens is they turn a marriage green card case, which first you file the I-130, and once approved, it goes to consular processing, and you finish up the work at the embassy. It causes them to bypass getting the green card at the embassy and just getting a basic visa to enter the United States, kind of like a tourist visa, and then finishing up the green card process here. But what that leads to is the foreign person, the foreign spouse coming in, not having a work permit and just sitting at home for many, many months, 6 months, a year, not doing anything until their green card interview. And that's really hard in a lot of couples. They want to come here and work and start their lives. So that's problematic, and it increases the fees and costs and all this kind of stuff in general. So it's not something I recommend unless people really want to do it. But mentioning these marriage green card cases, I have a guide called the Ultimate Marriage Green Card Guide, the best one out there, frankly, even though compared to paid ones. This is free. Just go to marriageimmigrationlaw.com. That's marriageimmigrationlaw.com, and send it and download the Ultimate Marriage Green Card Guide. A lot of information there that can help you go through all this process. But thank you for the question, Alassane. Alassane asks, hello sir, can you please elaborate more on the 90-day rule and whether it is in the USCIS policy manual? So the 90-day rule is something that confuses a lot of people, including lawyers. I've seen a lot of lawyers not understand it or know what's going on or just heard something and then run with it. The Department of State has a thing called the 90-day rule, which is if you come in on one visa category and do stuff that doesn't match that visa category within the first 90 days, they may assume you did fraud. For example, you come on a tourist visa and then you start working within 90 days. They say, oh, you weren't intending on coming with a tourist visa. You lied to us when you applied for that tourist visa or at the airport to the airport officer. You were really trying to come to work, so we may accuse you of fraud for that. That situation doesn't happen as much, and that's not the thing. The thing that worries people is usually in marriage cases, and this is what lawyers are scared of and they scare their clients about, is if you enter the United States with a tourist visa and you get married within 90 days and file a green card case within 90 days, the USCIS Immigration Department in the US might say, oh, your intent was just to get married from the start and it was not to come as a tourist, and you lied to us, and they may deny your case for fraud. There's very, very, very few times this has ever happened in regards to a case where you're married to a US citizen. They generally don't do that. There is discretion of the officer, but that's not generally something that happens. But if you had another category, for example, you're marrying a green card holder and you do it really quick within 90 days, they could look at it. And so the USCIS policy manual, USCIS is the immigration department in the United States, they don't have a 90-day rule. They just say we look at the totality of the circumstances. It's Department of State and the embassy system that has that. Historically, there was a thing called the 30, 60, 90-day rule, which is if you do get married, file a green card within 30 days, they'll assume it's fraud, and then 60 days they may, and then 60 to 90 days they may or may not, blah, blah, blah. That was never really the case. And again, there's cases, there's Board of Immigration Appeal cases that say for, like, if you're married to a U.S. citizen, not to hassle people about this. I filed cases, where they got married immediately after entry, at the same time, I've seen people get married within the first day and file the next day and be okay. But the thing with immigration, it's always up to the discretion of the USCIS or embassy officer you're dealing with. So you just want to be careful. First of all, obviously, don't lie, don't misrepresent your intent. Just talk with a lawyer, and best to really talk to a couple of different lawyers, because I've seen a lot of lawyers really almost destroy people's lives over this, or have them submit waivers when it's not needed, making admission, very foolish kind of stuff, and it does frustrate me seeing this bad lawyering, even from lawyers that have been doing for a while, even lawyers here on YouTube doing videos. They've got videos about some nonsense like this, and I've had clients talk with them and talk to me, and they almost have their lives ruined for not properly understanding the 90-day rule. This was a general overview. It's much deeper, and we need to talk about what's going on in your specific case if you're having this issue, to see what's appropriate and what's not. But again, I think a lot of the information on the internet and on videos about the 90-day rule is 100% wrong. So talk to different lawyers, schedule a consultation in my office if you like, and I give you my opinion after knowing all the facts of your case as to what's going on and what's appropriate. But Hassan, thank you for your question. It's a really important one. Do you have any comments on Judge Metha's ruling on the diversity visa lottery winners gain their visas but limited to 9,095 persons? So I'm not following this that closely, but the diversity visa is the green card lottery. Every year the US can give up to 50,000 green cards to people randomly chosen. Normally probably 30,000 people actually get the green card. Because of the travel bans and all that kind of stuff, people have had problems. They're not getting their green card interviews, and they sued about it. And I think the lawyer Curtis Morrison is a lawyer on it, and Judge Metha is a judge on it. And I just read some tweets, so I haven't read the whole thing, but apparently they're limiting the number of winners and they're randomly going to be chosen. It's kind of a bizarre system that they created. I just wish they would give it to all that were part of it, or part of that class. But I haven't read the case, so I don't want to comment too much. I just read what people have said about it on Twitter. But it's, in one sense, it's good that some people are going to get it, but it's kind of arbitrary if they're going to randomly choose people up to some limits. I don't really understand what the impetus or what that logic is based on, but again, I haven't read the decision, so I don't have more than that to talk about it, but thank you for the question. Artie asked, hey there John, good to see you. What do you think about interfiling medicals before receiving the RFE? Do you recommend it? I don't. I talked about this earlier. I don't like sending an important document like that unless you're willing to, get another one. So let's say you mailed it in, USCIS lost it because it was not associated with your file, and then you're forced to get another one. Then that's the thing. I have a colleague who knows how to make barcodes. They're able to make the barcode needed, so when USCIS gets a document, they can scan it and attach to your file. I kept these, she did a breakdown of how to do it. I kept a copy of it, but because I haven't needed to interfile or done so, I'm not doing it. The reality is this RFE kind of for the medical interfiling you're talking about, these are, for those who don't know, when you have a green card case pending, many times, in my office in particular, we don't submit the medical checkup with the application, we do it later, but USCIS is trying to finish up a lot of these employment-based cases before the end of the fiscal year. So the government's year is not January 1st to December 31st, it's October 1st or to September 30th or whatever. And so September 30th, a lot of people who are in line for a green card may not get it in this year because the government hasn't got their stuff done, and part of the stuff they need done is the medical checkup. So you want to get the medical in to kind of get things up and running. But what I'm seeing is USCIS is issuing RFEs for all my employment-based cases. I even got a whole family's RFE today saying please mail in the medical. So the best thing to do is do the medical, have it ready, and submit it. This October 1st situation is interesting. I talked earlier about the COVID-19 vaccine and the requirement October 1st. Probably the reason they didn't make it immediate and did October 1st is because that's the beginning of the fiscal year. They want to try to get the green card medicals for these employment-based cases in as soon as possible. And if they all of a sudden added a requirement for the COVID-19 vaccine, then it would mess things up because they have to do another RFE for the COVID-19 vaccine, and it'll delay the case so much that the green card numbers for employment-based cases in this fiscal year would run out, and it'll be a disaster. So that's an interesting thing. That's probably why they did that. That's a neat one right there. But going back to your question, I don't typically interfile, but it's up to you. If you want to be safe, just have a backup because I mean, do another medical if needed, do it quickly. You might have to pay for it, but just be safe. That's the thing to do. I'll be doing ask, my employer is concurrently filing and pre and processing Form I-140 adjustment status for me. Can Form I-24 be filed for spouse and 2 kids at the same time as they're currently in Nigeria? It can. I remember the first time I used I-24, I submitted with the case, and then like 3 or 4 months later, they mailed it back to a receipt that said stamped that said received. I was kind of confused, but it ended up working out. It's probably better you file the I-140 and the I-485, get the receipt or get it approved, and then send the I-24 to show that it's been approved. Now send it over, or at least and they have a receipt. So it's probably a better thing to do, but your attorney is going to know what to do about that, so talk with them. Actually, I had a consultation a couple months ago with a woman who's a corporate attorney, that's immigration attorney, didn't know about the I-24, had no idea what to do, and her husband and 2 kids were almost going to miss out on the green card. And this woman had been filed immigration law for 20 years. I was very surprised to see that. So if the employment lawyer doesn't understand it, schedule a private consultation with some other lawyers, see what they say. But probably, and I can't say for sure because this is general guidance, not education kind of stuff, not for your case, I'd probably wait to get the receipt for the I-140 and the I-485, and maybe just get an approval for the I-140, frankly, so you don't spend money on something like that, unless the employer's paying for it, then whatever. And then file the I-24 that way, so that you could connect the I-24 with some receipt numbers that way. But thanks for your question. Srivani follows up, when my priority date is current, does the H1, H4 visa extension given only for 1 year? If yes, why is so? It's not that your priority is current, when you have an I-140 pending, and again, I don't do employment-based cases, but there's this rule where you keep renewing your H1, H4 indefinitely until the case is finally approved. I think the regulation says you can only renew it, I think it's more than 1 year. I think it's like 3 years initially, then 1 year at a time. But Srivani, I don't handle H1, H4, EB2, EB3 cases. So talk with your employer's lawyer, or I can find the answer. I just got to go research it. Schedule a private consultation, and we could talk about that. Hi, attorney. Can a person who's trying to take USMLE exam for national graduates for doctors acquire a tourist visa? What are the requirements? You can always apply for a tourist visa. If you want to give a test, that's fine too. The State Department's website breaks down what you need for a tourist visa. I think I did a video on that on YouTube at JQK Law's YouTube page, a whole video. So when you take what's the requirements, that's too big a thing to talk about because I don't know anything about you to see how it fits you. So you can schedule a private consultation and we can talk about that. But in general, you have to file for a tourist visa and fill out the form, have some documents, go do an interview. You may get approved, you may not. Well, best of luck though. Sarong asks, what's the difference between the visa bulletin and the MVC Vermont processing times? Seems like the dates don't match. Does the MVC processing time hold precedence? They're completely unrelated and different things. The visa bulletin talks about when your date's current if you're filing a preference category case, like a family-based F1 through F4, an employment-based case EB1 through EB5, or doing a diversity visa lottery. The Vermont Service Center is an organization in the United States where it processes certain kinds of cases, and they have their own processing times for USCIS cases. So it's apples and oranges, there's no comparison. All right, with that, I want to thank everyone who joined us. I'll be back next week, 6 p.m. Wednesday, 6 p.m. Pacific time, to take your general green card and immigration questions, all that kind of stuff. And if you're interested in doing a fiance or marriage case, definitely check out the Ultimate Marriage Green Card Guide at marriageimmigrationlaw.com. You'll thank me once you download it and see, wow, this is a lot of good information. So with that, everyone, God bless, be safe, and I'll see you all next week. Bye-bye. I hope you enjoyed this educational video. We have a second channel with much more information as well at JQK Immigration Clips. Please check that out. Also, you'll find our social media site has a lot more videos, images, and information about the U.S. immigration process. Please check those out on the various social media websites.